Good evening. We're up for round two with William Simmons. And I want to clarify, just starting off, I'm not trying to be a dick to William Simmons. I enjoy talking about the law. I enjoy reading the law. I enjoy interpreting the law. I enjoy trying to understand the law. I enjoy talking about the law. So if you think I'm attacking you, Mr. Simmons, I just want to allay that suspicion, that belief. And I want to affirmatively declare that I am just engaging with you in an exercise of research and intellect and understanding. So do with that what you will. So he wants me to read this whole thing. It says somewhere in here, no skipping words right here, no skipping important words, because apparently I skipped important words. So he's gonna show me what for. So, and I'm taking you along the ride with me. I don't care how long it takes to get through this video. You and I are gonna buckle in, and we're going to go through this, and we're gonna see how stupid I am, or at least purposefully obtuse. I know you're smarter than this misleading video. Thank you, sir. You are being purposely obtuse. I disagree. I think I was being very clear. Words are important, and you seem to overlook words you do not like at the moment, similar to using logic like a hired cab. I don't believe I overlook words that I don't like. I don't have a particular opinion on the Lacey Act. I didn't go into this with a particular opinion on the Lacey Act. I went in knowing that the United States doesn't enforce foreign laws. He says, first, criminal versus civil. I know the BS dictionary definition of criminal v. civil. Well, okay, but I don't really rely on a dictionary definition of it. There are important actual procedural definitions. There are important constitutional differences between criminal and civil. He says, basically, criminal law is said to be a system of laws concerned with the punishment of individuals who commit crimes. Well, that's a very, very vague definition, but okay. Civil law is said to be two individuals disputing their rights and suing each other. That's, again, a really vague and oddly specific choice of definitions. I don't know where he got them from, and I don't really care. I would phrase them somewhat differently. Criminal law requires the protections of the Fourth, Fifth, Sixth, Eighth. There's a variety of protections that kick in as soon as something turns into a criminal matter. For example, in a criminal matter, the standard of proof is, generally speaking, beyond a reasonable doubt. In a civil matter, the standard of proof is, generally speaking, preponderance of the evidence, a much lower standard of proof, significantly lower. In a criminal matter, if there is going to be a potential for incarceration of 6 months or longer, then you have a right to a jury, and you don't have to pay for that jury. Whereas in a civil matter, if you have a right to a jury, you have to pay for the jury. There are jury fees involved in it. You're not just given one gratis. In a criminal matter, if there is even 1 day of potential incarceration, then you are guaranteed the right to an attorney. And if you can't afford an attorney, then one will be appointed for you. In a civil matter, you have no guarantees for an attorney. You could be as poor as a pauper, and the government doesn't have to. They're not obligated by the Constitution to provide you with an attorney. And there are also subsequent factors. You can't be incarcerated over a civil matter, generally speaking. You can't. You don't get a criminal record over a civil matter, generally speaking. I mean, there are a lot of differences between the I'm I'm going to say that these two definitions are woefully inadequate for really breaking down the differences between the two. I mean, there are substantive and substantial differences between the two. He says, notably, for criminal law, the prosecution involves the government deciding whether to punish an individual for either an act or an omission. Yes, criminal law would require there to be a prosecution, whereas the government can sue and be sued. The U.S. federal government can sue under civil laws and be sued under certain civil laws. So just because it said United States v. McNab, it doesn't necessarily mean that it is a criminal action. I am almost positive that in U.S. v. McNab there was a criminal action and there was a civil action, and they were both done separately. But I could be wrong on that. He says, of course, the federal government used the Interstate Commerce Clause to justify their actions because the Supreme Court is composed of a bunch of jackass lawyers in black robes who believe they can justify anything via the Interstate Commerce Clause. According to those assholes, the Constitution can be summarizers by Congress shall have the power to regulate interstate commerce. With that power, according to the 9 clowns in black robes, Congress has the power to do anything. The rest of the Constitution is just stuffing. See Wickard v. Filburn, a topic for another day. Wickard v. Filburn is a fun one from law school. In Wickard v. Filburn, the defendant grew, I think it was some sort of a grain, and there was a regulation in place that put a limit on how much grain you can grow to sell. And so what this guy did is he grew as much grain as he could sell, but he also grew extra grain. And that extra grain he was intending to use for his own purposes, to replant his fields, to feed to his animals, to use in his own house for his own food, etc. And the Supreme Court came down on the side of the government that if everybody did what the defendant did in Wickard v. Filburn, then it would essentially ruin the market for that particular grain because the market would be flooded for it. And so, people would go out of business and it'd be just terrible for the United States or whatever. Now, I don't necessarily agree with the court on Wickard v. Filburn. That's one of the ones that I personally disagree on. And they have backed off on the Commerce Clause for other things like trying to justify laws against bearing a firearm in a school zone. A federal law against bearing a firearm in a school zone was found to not be closely enough related to the Commerce Clause to allow Congress to enact that particular law. But this whole sentence, I mean, this is somebody who doesn't understand the nuances of the law. They're not a bunch of jackass lawyers in black robes. They are very learned people who understand things. And you could disagree with them, and you could have reasoned and rational disagreements about the decisions they make. And they even disagree with each other over the decisions that they come to. That's why there are 9 times out of 10, there is going to be a dissenting opinion, because reasonable minds can draw the line of distinction at different spots. The whole reason why it gets to the Supreme Court, generally speaking, is because the different circuits can't agree on how that particular thing is supposed to be interpreted. So a bunch of very intelligent people have already looked at it. Lawyers have made brilliant arguments on either side of it, and judges have made well-reasoned decisions on either side of it, and it's come down 2 different tracks in at least 2 different circuits. That's typically how it gets to the Supreme Court. So you don't like their agreement, and that's great, but that doesn't make them a bunch of jackass lawyers in black robes. I mean, if you want to lay out your reasoned disagreement, that'd be fine. He says if you can describe the difference between a tax and a fine, you can handle the difference between a criminal act and a civil violation, both of which are prosecuted by the government. Well, civil violations aren't necessarily prosecuted by the government. The government would be the plaintiff in that particular case, not the prosecution. Now, you could still say plaintiffs normally they're prosecuting a case against the defendant. The plaintiff is prosecuting his civil lawsuit against the defendant. You could use the language in that way, but I don't think that's what you mean. But the difference between a tax and a fine is that there is no element of culpability in a tax. A tax is levied based on some standard, like if you make X amount of dollars, you pay X amount of tax, or if your property is worth Y, you pay Z tax, etc. Whereas a fine, there is some level of culpability, and there is, generally speaking, some sort of at least administrative, if not a actual civil proceeding, in order to levy that fine, unless the fine is a criminal fine, in which case there's definitely going to be a criminal proceeding. So you're really fast and loose with the word fine. You're not being really specific on what you mean by fine. But again, I think the big difference is taxes come without any culpability, whereas a fine requires at least some element of culpability. And he says, in any event, he'll give me a step-by-step guide. Ooh, I'm looking forward to this. No skipping important words. All right. I will do my best not to skip any important words. He says, here is part of what I said. Consider the Lacey Act, 16 U.S.C. 3370. Again, it's 3371 et sequitur, where he quotes, without putting quotation marks in there, but this is a quotation, provided that when the violation involves fish or wildlife or plants with a market value of less than $350 and involves only the transportation, acquisition, or receipt of fish or wildlife or plants taken or possessed in violation of any law, treaty, or regulation of the United States, any Indian tribal law, any foreign law, emphasis added by him, I guess, or any law or regulation of any state, the penalty assessed shall not exceed the maximum provided for violation of said law, treaty, or regulation, or $10,000, whichever is less. He says, in parentheses, perhaps I should have quoted from the criminal section, but it makes more of a point to note that even amounts less than $350 are covered. I think what he means is in the criminal section, it does cover amounts less than $350. And indeed, it does. So he says, what I typed, and he capitalizes typed, did you know that under certain circumstances, it is a federal crime to possess an undersized lobster tail because Honduran law makes such illegal? Yes, that is technically a true statement. But it is under very, very specific circumstances. And one of those circumstances is not if you kill a lobster in self-defense. Honduran law, the Honduran laws that were dealt with did not include killing lobsters in self-defense. So I don't want to skip important words here, sir, but I notice you didn't put some of those important words in there. He says such a sentence is 100% as qualified. Yes, it is. And I didn't say that his sentence, I did not state that this sentence is a lie. It is misleading, but it is not a lie. And it is hyperbolic. He says he used United States versus McNab as one example. There are more. Congratulations. McNab was a shitty example. Once again, McNab dealt with a very procedural question of whether or not foreign regulations are considered the same as foreign laws. Because in one part, it says any law, treaty, or regulation of the United States. And then it goes on to say any foreign law without mentioning regulations. So does any foreign law include any foreign regulations? That's what McNab dealt with. McNab doesn't, however, deal with your underlying generalized assertion that the United States is enforcing Honduran laws, because the United States is not. It's demonstrably not. which is why I made a whole video showing why the court in McNab was enforcing U.S. federal law. And Honduras had enforced Honduran law. He says, consider this portion of the Lacey Act. It is unlawful for any person, ... to import, export, transport, sell, receive, acquire, or purchase in interstate or foreign commerce, A, any fish or wildlife taken, possessed, transported, or sold in violation of any law or regulation of any state or in violation of any, and again in all capitalized, foreign law. Congratulations. That is a portion of the Lacey Act, and I am considering it. Okay, I am done considering it. Suppose, okay, so now we're on to suppose. Suppose if I go to Florida and unknowingly purchase an undersized lobster taken from Honduran waters in violation of Honduran law and transport the lobsters to, I believe, I don't want to, what did he say? Skip important words. So technically he wrote top, but I'm going to interpret this as to. So he said, and transport the lobsters to my restaurant in North Carolina to sell. I have committed a federal crime, for I have, number 1, received/acquired, number 2, purchased, number 3, transported across state lines, and number 4, sold lobster tails illegal under Herdian law. Now, I don't know if Herdian is an important word, but I'm going to assume that you meant Honduran. So, okay. So we know that the lobster was taken from Honduran waters in violation of Honduran law. And you unknowingly did it. Congratulations. So, did you or did you not commit a crime? And at this point, I would have to say, I don't know, because I don't have enough information. From what you have listed there, I don't have enough information to know whether or not you have committed a crime. And you think you listed all the elements of a crime, but you did not, sir. He says, oh, and good luck with it. I did not have the mens rea to commit an illegal act because I did not know the lobsters were illegal defense. Lol, the chant of every criminal ever caught buying illegal goods. That is funny, though. You should be a comedian. I have read all of your words, sir. I have read all of your words. And now we are going to look at the actual law because that is where this works best. So he is talking about a criminal violation. So we are going to move past the civil penalties and we're going to move down to the criminal penalties. Any person who knowingly imports or exports any fish or wildlife or plants in violation of any provision of this chapter, or violates any portion of or any provision of this chapter other than subsections B, D, and F, which don't apply to us. We're looking at subsection A of section 3372 of this title by knowingly. Engaging in conduct that involves the sale or purchase of, the offer of sale or purchase of, or the intent to sell or purchase of fish or wildlife or plants with a market value in excess of $350. Knowing. That the fish or wildlife or plants were taken, possessed, transported, or sold in violation of or in a manner unlawful under any underlying law, treaty, or regulation shall be fined not more than $20,000 or imprisoned for not more than 5 years or both. Each violation shall be a separate offense, and the offense shall be deemed to have been committed not only in the district where the violation first occurred, but also in any district in which the defendant may have taken or been in possession of the said fish or wildlife or plants. So that is subsection 1 for criminal penalties. We know that there was no violation under subsection of 1 because they had to do it knowingly. And in the supposition, in the hypothetical. We don't know. Now, I don't want to skip any important words, but this is an an. An would indicate a singular undersized lobster tail. Am I missing an important word? Is an undersized lobster worth more or less than $350? I don't know. So that might be another issue. But we haven't finished, and I don't want to miss any important things because there is a subsection 2. And subsection 2 is also, well, it is a different level of mens rea. But let's read it. Any person who engages in conduct prohibited by any provision of this chapter other than B, D, and F, and in the exercise of due care, should know that the fish or wildlife or plants were taken, possessed, transported, or sold in violation of or in a manner unlawful under any underlying law, treaty, or regulation, shall be fined not more than $10,000 or imprisoned for not more than 1 year or both. Each violation shall be a separate offense, and the offense shall be deemed to have been committed not only in the district where the violation first occurred, but also in any district in which the defendant may have taken or been in possession of the said wildlife or plants. And then D or F requires knowingly again, and that's D and F. I think one is, I think they're labeling requirements. Anyway, in the exercise of due care now. What is in the exercise of due care? In the exercise of due care, this is United States versus Mitloff. This is the best one I could find. And this is in a footnote. So this is dicta. Dicta in the exercise of due care, which is a negligence standard. So it requires criminal negligence. That is what we are looking at there. In the exercise of due care requires criminal negligence. So the government would have to show beyond a reasonable doubt that a reasonable person would have known that these lobsters or whatever they are were taken illegally. They were taken, possessed, transported, or sold illegally. So the whole I did not have the mens rea requirement to commit an illegal act because I didn't know the lobsters were illegal is exactly a defense. Unless the government goes for the misdemeanor, in which case they would have to show that you should have known in the exercise of due care that the lobsters were illegal. So that is where we're at there. As far as knowingly is concerned, just so you know, this is United States versus Bailey 444, U.S. 394. Knowingly means that you're aware that the result is practically certain to follow from his conduct, whatever his desire may be as to that result. So if you're wondering what knowingly meant in 16 U.S.C. 3373 D1 A and B. And then Flores Figueroa, this one was pretty interesting. I enjoyed reading it. It involves the use of knowingly. Knowingly means that, like this use of knowingly here, means that knowingly has to apply to every subsequent portion. The use of knowingly here means that knowingly applies to every subsequent portion. Using knowingly here means knowingly applies to every subsequent portion. So that was an interesting thing to read as well. Now, there is one other thing that I want to address in here, and that's Stunt Dummy. Stunt Dummy apparently got a bit of butt hurt going on. He asks, why are you talking about Canadian law? Now, I want to point out Stunt Dummy pulled his video down, or at least last I checked, his video was still pulled down. Yeah, so there is no video there. So congratulations, Stunt Dummy. I remember somebody else hiding evidence and then requesting proof that evidence existed, and that was similarly a losing tactic. Why are you talking about Canadian law? It's because you, Stunt Dummy, brought up Canadian law in your argument with Mouse, suggesting that the First Amendment doesn't apply to Canadian law. Malice is an American citizen who broke an American law with other Americans on American soil. Which law did he break? Stunt dummy. Cite your source. He says there should be no need for extraterritorial jurisdiction or extradition. You're the one who brought up extraterritorial jurisdiction. You're the one who brought up Canadian law. I'm going to tell you why I brought up extradition in my video response. Now, you're responding on the wrong video, but the reason why I brought up extradition is because courts have what is called jurisdiction. It's not just a concept for sovereign citizens. Courts have jurisdiction. For example, federal courts. Can federal courts hear criminal cases involving violations of foreign law? No, they cannot. Why not? Because Article 3, Section 2 grants federal courts the power to hear criminal actions arising out of federal law. It does not, there is no provision allowing a federal court to hear criminal actions arising out of foreign law. They don't have jurisdiction for it. They can't hear it. Similarly, Colorado has, I want to say it's Title 18, Section 1-201. I'm going to go with Title 18, Section 1201 of the Colorado Revised Statutes states that Colorado courts have jurisdiction over Colorado offenses committed in the state of Colorado or with basically a substantial nexus to Colorado. Could be planned in Colorado, could have some effect in Colorado, but it has to be a Colorado offense. It doesn't allow them to try people for Canadian offenses. So the only way an American citizen who's currently in America is going to be tried for Canadian offenses wherein the First Amendment would not apply, because you got to remember the First Amendment applies to the states and the federal government through the 14th Amendment, or to the federal government and the states through the 14th Amendment. But because it applies to the states and the federal government, there is no way that the First Amendment would not apply in the U.S. to any federal or state action. So what you had to have been talking about, unless you are as insane as Mouse is, and I gave you the benefit of the doubt, sir. You were arguing with a crazy man, but I was hoping that you are not in fact crazy. The only other alternative is that you were talking about extradition. So I brought up extradition. That is the sole reason why. It's because the courts had the power to hear certain cases, and they do not have the power to hear violations of Canadian law. Now, I want to point out, just in case you think that I'm a little picky, I want to point out 8 hours ago, there's this. He says, I will upload it. 8 hours ago, he said that he will upload it. And he has not done so. Now, I want to be perfectly clear. I am done with Stunt Dummy. He is not bringing up contentions of law. He is trying to bring up drama. And I have no intention of talking about drama. So as far as I'm concerned with Stunt Dummy and his stupid video, it was a drama video, and I was only talking about the legal aspects of it. And if he cannot separate himself emotionally from his butthurt enough, well, I'm just done talking about it. So that was this video. Thank you for watching. I hope this was suitably long enough for Ted Nugent to drop a turd. Thanks for watching. Have a great day.